Right, so the first one is about the Employment Rights Bill, uh, which had an update as yesterday, as far as I'm aware. This is going to be done by Chris Weaver, so I'll hand over to Chris.
Great, thank you very much, and good morning, everyone. I've seen various people at breakfast, coffee, and elsewhere, but hello to all of you, including online. Not going quite as planned, but I would say that we only installed the kit yesterday, so I was very aspirational in hoping that we'd be fully up and running today, but we're getting there. So the Employment Rights Bill, almost the Employment Rights Act. It's now gone through all of its parliamentary stages as of yesterday. Finally, particularly the Tory and crossbench peers who were continuing to block it in the Lords gave way yesterday. So it's now just waiting on the signature of the King and will be law. So it's going to run through, say, current status. It took a long while, partly because it is a relatively complicated bill. It's a relatively controversial bill for some parts of business, some political parties, but it did complete all its stages yesterday, and we expect that to receive royal assent before the end of the year. What I would say is that doesn't mean it all comes into force before the end of the year. Each different section has different commencement dates, and I'll come back to this, but there's a lot of consultations out there at the moment on how each of these sections are going to be implemented. But the earliest measures you'll start seeing coming in from next spring. So key provisions in the bill. You'll have seen a fair amount of coverage in recent weeks about dropping the day one right to claim unfair dismissal. As basically part of the government's compromises to get it through the parliamentary process. So that's now been amended to 6 months. That's still a significant improvement. It's a quarter of the length that it used to be, a 2-year qualifying period. Now I'm going to run very quickly through the other bits. You'll have seen this both at previous secretaries' briefings, but also at some of our consultation conferences and the like. But a statutory probation period for new employees, a ban on fire and rehire practices, strengthening sick pay, enhanced redundancy protections and trade union rights, new duty on employers to prevent third-party harassment, new rights for zero low-hours contract workers, and establishment of a Fair Work Agency to oversee all of these things. So that Fair Work Agency supersedes some of the organisations that are out there previously, so the Gangmasters Authority and others, and brings them under one overarching employment rights body. But it will also have additional powers to those previous bodies. So, as I said, not all of the clauses will come into effect next April. There's several that will be staggered as consultations and secondary legislation is needed to put them into action. So these are a few that are out there at the moment. So rights of access, and just say we have or are in the process of responding to all of these. Duty to inform workers of right to join a union, enhanced dismissal protections, particularly around pregnant women and new mothers, and bereavement leave. Another one that's come out in the last couple of days is around the provisions around allowing trade unions to undertake electronic balloting rather than the previous requirements that all ballots had to be done by post. As well as, I hope, enhancing turnout. That is going to be a massive saving, not just for us actually, but for the trade union movement as a whole, millions upon millions. Quite where it leaves the likes of Civica and others who have done very well out of postal ballots over the years, we'll wait and see. But you can imagine at the moment, just out there right now, we've got a postal ballot on industrial action in Scotland. We've got the election for the JVP. We've got 2 elections going on for honorary treasurer, the interim one, and then the full term to take us forward from next conference. Being able to move all of those online will be really significant. You know, just looking just now, the Unison have announced their election result, and again, a relatively poor turnout. You would hope that across the movement, you'll see that increase. So some of the other ones are coming forward. I've mentioned the electronic and workplace balloting, but you've got the fire and rehire provisions, the unfair dismissal implementation, obviously 6 months now, not day one. Trade union recognition, the powers of the Fair Work Agency, because this is really important. It's not just about the legislation, it's about the powers to enforce and the powers to penalise where employers aren't respecting the law. And the employment status reform. And this is an ongoing debate and probably won't be resolved once and for all through the status, but in law, employees and workers are treated differently. And the easiest example of this is your sort of gig economy type stuff and the debates around Uber drivers. Were they employees of Uber or are they workers who are contracted to them? And there needs greater definition of that as the economy develops. So you can see from that, there's an awful lot of work for government to do and for us to do in terms of influence in that process. And we have huge opportunities in doing that. There were changes that we sought and changes that we sought not to be made to the primary legislation, so the Act, but there's an awful lot in there, particularly I'd highlight around supply teachers. So there are provisions, very loose provisions in the Employment Rights Bill around agency workers, but the implementation of those and quite how wide-ranging they are, quite how beneficial they are to agency workers, including supply teachers, will come down to the secondary legislation and statutory guidance. So we are across the organisation hard at work at seeking to influence those, meeting with colleagues in the Department for Business and Trade, with colleagues in civil servants in the Department for Education to make sure we secure the best possible deal for our members. So implementation next. What are the implications for teachers? So clearly there are elements of the legislation which probably won't have a huge implication for our members, or certainly for the majority of our members, because the terms and conditions for teachers are superior to the basics in the economy in terms of legislation. But there are still lots of benefits that we can take advantage of, particularly around the day one rights, the provisions around agency workers and their implications for supply teachers. You see their redundancy and leave protections. And the real challenge for us as an organisation will be not only supporting those members and being able to make use of those new powers in terms of casework, but will be the expanded access and recognition rights in workplaces. Some impact in the state sector, but potentially transformational in the independent sector, where their ability to keep us out of their workplaces will be greatly reduced. And we'll need to think about that in terms of our policy, in terms of our contracts, but we'll also need to think about it in terms of our organising, and I'll come back to that because there are huge opportunities for us, but we need to be ready to take them. And as I already said, union engagement is crucial in those ongoing consultations to make sure that we can make the most of it. So we're in the stage now of preparing for that implementation over the course of 2026, 2027. Probably be about 18 months start to finish for everything to fall into place. We're responding to those current or live consultations, but also waiting for those that are still to come, and they will come thick and fast in the spring. We anticipate secondary legislation, so often in the form of what they call statutory instruments, to put some of the operational details in place. And we will need to be working with you as our local secretaries, but and to say most of the scope of this covers England, Scotland and Wales. Northern Ireland has a different industrial and employment rights legislation, but we'll need to work across Great Britain in terms of this, in making sure that you're aware of those new rights, but not just you, but all of our caseworkers. And I know obviously many of you will be caseworkers as well, but our health and safety reps. There is new provision in there for facilities for equality reps in the newer legislation. All of our workplace reps, our contacts across the board, we need to be geared up and ready to make use of this. We've campaigned hard as a trade union movement for literally decades on many of these issues. And you were promised good news earlier in the morning. This may well be it for the day. But genuinely, this is the most transformational piece of trade union employment rights legislation, certainly we've seen in my lifetime. I suspect in the lifetime of many, if not most of the people in the room. But it's meaningless if we don't do anything with it. So some thoughts on actually, I'll do this and I'll come back to the thoughts. The other thing is we're always greedy for more. So there's a lot of debate over the course of this bill. Did it go far enough? Did it do everything that trade unions want? I've put a shopping list up on the screen there. This isn't to say that we're calling for all of these things. Some of these things, as far as I know, we've never debated as a union. But I just wanted to give you a flavour of the debates which are out there about actually, when it came down to it, the trade union movement, the TUC and others basically thought, we've already got a situation for a long while, Lib Dem MPs, but certainly Tories, crossbenchers, the hereditary peers seem to be particularly appalled by this. We're trying to block this. Now, on the other side, we could have been saying, no, it needs to get changed. And actually, the calculation was, we need to get this onto the statute books. We need to make use of all the stuff it's got in it, which are a massive step forward. And then we're going to come back for more. And there'll need to be a debate in the movement as to what more looks like. Will it need to be a debate within NSUWT as what the more looks like? But you've got a sample of some of the things that are being talked about there, about collective bargaining rights and a framework for making that operate. Barriers to collective action, legal protections for solidarity, what's sometimes called secondary action, further action bearing down on the use of fire and rehire and 0 hours tactics, stronger sanctions for employers who violate rights, issues around blacklisting and union discrimination, and this going back to this issue of the definition of worker and employer, making that clearer and actually broader and more encompassing. But in the meantime, we've got plenty to be getting on with. So I think I've broken this down into 3 from memory. We need to make sure that you've got all the information that you need as secretaries to understand what's in this piece of legislation, all the opportunities that are in there and when they're coming into force and when you can start using that. And then you need to use that information to actually map it into your localities. Actually, that school that would never let us through the door, how can we use these additional rights that we've been awarded that will allow us to do that? What are the types of cases that you see coming through routinely that actually, whether it be around job security, working time, dismissal, actually the powers you've got here means that you can better address some of those. And I'm going to take this opportunity now, because I always do it, and I will do it again at the end of the day, I promise. How many of you in the room has won a case for a member and got them a good settlement this year? Or have won collective action in a school within your area and secured a win for members? How many of you emailed me to tell me about that so I could then promote it on our social media channels, put it into Teaching Today, put it onto the website? Tell me. This gives one, it's great for recruitment. It tells people what a good union we are, but it also gives heart to those who are facing intransigent employers elsewhere, that actually when the union stands up with its members, be it through collective action or the great work of our caseworkers, we win. And it gives heart to others. So you're going to get more wins now. Tell me about them. I don't care how many emails I get a day, the more the better. But also you need to be preparing the reps in your area, because there's a lot of this stuff that they will be able to deal with without necessarily calling on you or the regional centres. Make sure that they understand the new rights, and we will provide certainly resources, briefings, potentially webinars and training to help people get the head round what's available to them. But we need to start having conversations with employers, with head teachers, with MATs, and saying, okay, these things are coming in. What are you going to do to make sure that you're now complying with the new legislation as a teacher? This may be coming in April, but you'll have to be adhering to the law in April. You can't just then start planning for, okay, we need to provide this facilities time or these provisions for equalities reps or this level of access. They need to be compliant as of day one in the new law. And talk to members about the new rights they've got, but also lay claim to them. Our campaign for a new deal for teachers, which we ran during the general election, was really explicit about what we were calling for in terms of trade union legislation reform and employment law reform. And we should be really pleased about the fact we've secured most of those. Job's not done, and we will keep going back for more. I suspect it's one of these things that however much legislation we got, we'd always come up with new things to campaign for and further improvements, because that's what we do. But we don't need to be hesitant about the fact that this is a big win and we've played a significant part in securing it. And we need to go back and sell that to members. And then it's about securing and strengthening our position locally, particularly around recognition, facilities time and consultation arrangements. It's often, I was talking to a couple of people over the break and saying that technology is fantastic, but it's usually limited by the user's ability. So obviously not the case this morning. My ability to use all the technology is phenomenal. It's definitely the technology that's at fault. But you can also read across in that around the legislation as well. This legislation will only be as good as the people we've got on the ground and actually making use of it. Otherwise, it becomes a dusty piece of vellum in the Elizabeth Tower at Westminster. So we've got to make sure that every level of the organisation, we're geared up to take advantage of that and use it to build membership, to build activism and secure those wins for members. But with that, I'll draw it to a close, but very happy to take any questions or any discussion.